Background real quick. All right, good morning. Welcome to the 294th District Court. My name is Judge Chris Martin. I'm going to call this morning's docket. When I call your name, please say present or here so I can write you down. Joshua Lee Davis. Joshua Lee Davis, will you relay that? Oh. Eugenio Gonzalez Merlo. Thank you, Deputy Everett. William Goldner.
He's present, Your Honor. We're ready for a ring.
Thank you, Mr. Head. Shazmeen Jones. Is Ms. Jones here? If it's probation extension. That's okay. I'll read.
No, Your Honor.
Okay, we'll recall her. It's a probation extension. Benjamin Miles.
He's present.
Thank you, Mr. Nicholas. Jordan Patillo. Jordan Patillo.
Gordon. No, Your Honor.
I believe there may be a warrant for that case already. Julie Polens. Julie Polens.
No, Your Honor.
Harry Sanders.
No, Your Honor.
Kristen Sipes.
He's present.
Savannah Toon. Ms. Toon is here. Colby Stefka. Yes, thank you, Ms. Brumbelow. Lisa Peace, waiver of arraignment filed, granted, pretrial set March 28th. March 28th. Jonathan Ridenour, waiver of arraignment filed, approved, granted, pretrial set February 9th. Brandy Palmer, waiver of arraignment. This is in CR 22-386, CR 22-387, waiver of arraignment filed, approved, granted, pretrial set February 21st in both causes.
He is here and Mr. Hubert has set us hanging on his place, so.
Who?
Okay.
No. Who are we talking about? What defendant are we talking? Mr. Euler filed waiver of arraignment. I approved that yesterday. So check in, have them check in with pretrial release with Mr. Waddell and make sure that that's taken care of. If it is, then the waiver's been approved and pretrial set February 21st that Mr. Euler requested.
Thank you.
John Baird. John Baird. Will somebody check the hallway for John Baird?
John Baird. No, Your Honor.
Jason Barnes. Thank you, Mr. Nicholas. Ronnie Cotton. Oh, waiver of arraignment. Do you remember the date on February 9th? All right, Mr. Manning filed a waiver of arraignment that's been approved and pretrial is set February 9th. Treasurer Holick.
No, Your Honor.
John Lejean. Thank you, Mr. Nicholas. Hunter Tapper. Thank you, sir. Brittany Turner. Thank you, Ms. Abraham. Christina Ross.
Judge, she has joined the online.
Yeah, I told her to be on Zoom just in case the court wanted her to be on there. She's waiting right now, Judge.
Okay,
If you
well,
want a copy of the continuous, I can do that right now.
just wait and I'll recall the case in just a moment.
Yes, sir.
Jay Penny,
Waiver arraignment.
waiver arraignment approved. Pretrial set February 21st. Tyler McInnes. Thank you, Ms. McInnes. Danny Dittman.
Danny. No, Your Honor.
All right, and I believe that there is a warrant active for Mr. Dittman. Nash Fuller. Nash Allen Fuller. Jared Hayes. All right, and in this case, the court has recused itself, and the Honorable Christy Kennedy, who's present in court with me, will be presiding over that case. At the conclusion of the docket, I'm going to step down and let Judge Kennedy call that case, Mr. Schmidt. And are you Mr. McConnell?
I am, Judge.
Sydney Hip.
Yes, Your Honor.
Thank you. Noe Lamone.
He's here.
Yes, Your Honor.
Thank you. Jodine Lewis.
Here.
Thank you. Kenneth Riggs.
Here.
Thank you, Mr. Riggs. Hannah Short
Your
is
Honor.
verified in Grayson County Jail, I believe, as of
She's up
yesterday.
there. She's got an MTA. It's pending. I talked with the prosecutor up there. I'm not handling it. But I talked with the prosecutor. I believe she got court in the middle of this month, on May 17th. And they're supposed to get back with me. Tell me what they're gonna do on that.
Okay. And I believe that there was a 1716 filed on the bondsman. Are you aware of that?
I was hoping. it would-
Okay. All right. All right. We'll recall that. Mr. White, that's not your only case. So we'll recall that and get a new date here in just a moment.
Yes.
All right. Is there anyone whose name I've not called? Katrina Anders, Anders?
Yes, sir.
Oh, okay. Odd man out, right? All right. Thank you.
Always the last.
You're going to look at it again? Okay. All right. All right. Thank you, Ms. Sanders. Is there anyone else? We check the hallway. Anyone in the hallway and their name's not been called? Karen, will you check with Patty to see if there's anyone whose name's not been called so I can?
Shadman Jones is here.
Anyone else?
And the rest of them, I think, like it's.
Okay. All right. I'm going to step off the bench and let Judge Kennedy present.
This is cause number CR 22-00355, State of Texas versus Jared Hayes, counsel for the state, for the defendant and the defendant are present. I'm Judge Kennedy. I'm sitting by assignment to the 294th District Court this morning. And this case is set for announcements about what you're going to do with the case. That's what I expect to transpire. And then if necessary, pretrial this morning on behalf of the state. Are you ready to proceed?
Taylor McConnell on behalf of the state, ready to proceed now.
Thank you, defense.
Ready to proceed.
Is there an agreed recommendation in this case?
Yes.
What is the proposed resolution of this case? Is it going to be a jury trial?
Most likely.
All right. Then I'm going to need to talk about a date. Some dates that we talked about earlier, possibly February 13th, March 20th.
Setting a call date at this point, Judge, you'll be setting.
Those are actually jury trial dates. I'm getting a sign from the coordinator that she doesn't think those dates are right. So anyway, if you'll give us just a minute here. But the judge and I talked about those dates, and as we said, we're always last to know. Mr. Hayes, did you have an opportunity to read the scheduling order that the court sent? You should have received a copy of it. Well, one of the features of that order was that today would be the last day to accept an agreed recommendation. The court will not accept an agreed recommendation after today. You understood that? All right. All right, well, those dates were wrong. February 27th. And that is the day I anticipate having jury selection and trial. Today is the case of separate pretrial. I did note no one has filed any pretrial motions. Do you all need another pretrial hearing date?
Judge, I would ask.
Okay, I'll send it out to you. We'll go with this trial date. I'll send you a scheduling order that has that pretrial date on it. And I would anticipate it being approximately 10 days before. I usually have it 10 days before the trial, which would make February 17th. And I say that knowing that I have absolutely no idea what is going on in this court on February 17th, because this is not where I sit. But we'll let you know, and it may vary a little bit from that date, but it'd be approximately 10 days before the trial setting. All right. Mr. Hayes, are you presently reporting to pretrial supervision? All right, and no failed drug test or anything? Okay, all right. Is there anything further from the state today?
Nothing from the state, Your Honor.
From the defense? All right, thank you very much. We're in recess on this matter.
Thanks, Judge.
He was in person last time. I would say in person, but I don't know. Just really kind of people that love it and we might, you know, very good. People might see them and
It's really good.
And judge and all that, and he said, "Still want to hurt person." And he told me something, I mean, to make it cool. He said, "They're not, that's just, I mean, the judge is also better." And it was,
we have a special vetting. Oh, and we have that. Like some special vetting, but right now, there's no much vetting. So.
Trying to use the churches and stuff.
No. We were gonna go for a January 30th, meeting for a home, we got forward, but now they're saying, you know, started to learn, so we take that. So.
That's not all the photos.
The worst time along, I mean, probably, trial in January, all the time. I'm pretty sure. I'm beginning to. Thank you. I think she's actually number 3 now. Never much. I think she probably got you on that. I mean, probably so have opportunities. I think not, yeah. But she takes it one hand and gives away to the other. She doesn't buy these one and she sits off of her and provide it and so like it looks like she's getting information, but it's really not. It's not predictable. I don't know.
Really good.
Never heard of yeah.
I haven't been back there.
Oh, but she's on her way to the loop, so. You know. You're not just gonna. On one item.
We don't want.
If we hadn't gone so many times that she would hold the football back. I guess.
Except for on the call.
Mr. Schmidt, you have a second?
Yes, sir.
All right, we're gonna call the court to order. Do we have any counsel that's ready? Mr. White?
Sir.
Mr. Waddell, can y'all step outside? Just because it's a small courtroom, it's hard to hear. All right, Mr. White, who are you ready on?
We call him short.
Hannah Marie Short, CR 22-353. As the court stated before, she is verified in custody in Grayson County Jail. We're set for arraignment. What do you think? 30, 60 days on that, Mr. White?
Your Honor, let's do. You also got a charge of thing out of Fannin County. So I would say that maybe 60 might be a little more appropriate.
Okay. Any objection from the state? Set for arraignment. All right, court will set Miss Hannah Short for arraignment. Mr. White, would you have any objection for setting for arraignment and pretrial? I don't know, you think you'll see her between?
I probably won't unless I go up.
Okay. You know, objection to arraignment and pretrial in March. I've got March 7th, 9th, 28th. One of those dates better for you?
Your Honor, let's just do this. So
Okay. All right, court sets Ms. Short for arraignment and pretrial on March 7th. Has the state already disclosed discovery to Mr. White on? Okay,
they have no right. We can go in there.
great. Thank you, Mr. White. All right, who do you want to call next?
Ms. Lewis.
Jodine Lewis, CR 22-357. Come on up, Miss Lewis, right here by Mr. White. All right, Miss Lewis is set for pretrial.
Your Honor, after reviewing Ms. Lewis's case, I determined that there's probably there. I was going to talk to the state further about that matter prior to filing any motion to suppress. Talk with Ms. Heisel. I don't think they have any objection to a short 30-day resettlement pretrial some sort of consent.
Any objection from the state? All right, Mr. White, I've got February 7th, 9th, 21st. No, go ahead. And do you want us to go ahead and set it for an evidentiary date as well? In case you need it, and then we can always get rid of it if you don't.
That's fine. I just have a motion that February 9th.
All right, well, then we'll hold off then. So Miss Lewis, you're set for pretrial on February 9th. That will be at 9 a.m. Let me see if I can tell you where we're at on February 9th. I'm not sure what courtroom we'll be in. So we'll just give you notice of that. Stay in contact with Mr. White and your pretrial release officer. All right, you ready on Kenneth Riggs?
Yes.
Mr. Riggs, CR 22-362.
Your Honor, I got same issue.
All right, co-defendant, same case? Same issue?
Yes, sir. They're not exactly co-defendants. They each charge. The co-defendants, I would probably represent them together, but so the court knows there's two separate state legends, each of them had their own.
Understand. All right, court will set Mr. Riggs for pretrial February 9th at 9 a.m.
No, that's all I have.
Thank you, Mr. White. Mr. Head, are you ready?
Yes, sir, Your Honor.
Mr. Goldner, CR 22-376.
All right, he stepped outside.
Sorry, Your Honor, he said.
It's fine.
Bail supervision on it.
So he's getting his pretrial paper signed.
Yes,
Check
Your Honor.
that.
He's present now.
All right, this is William Corey Goldner, CR 22-376. Are you ready for arraignment, Mr. Head?
Yes, sir.
Go ahead.
Your Honor, Mr. Goldner has made a charge for the formal reason the indictment or plea of not guilty.
All right, court will enter Mr. Goldner's plea of not guilty into the record. We'll set this matter for pretrial hearing. Mr. Head, look at February 7th, 9th, or 21st, and if there's a date that's better.
Your Honor, it'd be possible to go as far as March for that. Mr. Goldner has actually just moved to Colorado, so he's gonna have to make like come back to Colorado, you know, and provided some additional information to the state. We hope we'll be closer to an agreement to try to save him from making as many trips as possible, just back and forth to Colorado.
Any objections from the state? What about March 7th or 9th?
Yes, sir, Your Honor. If we could do the 9th, that would be even better.
Okay, all right, court will set Mr. Goldner then for March 9th at 9 a.m. And Mr. Goldner, you signed your conditions of pretrial release with Mr. Waddell? And you, okay, great. Great. Once you sign and get the yellow copy, then give that stuff to Mr. Waddell, your pretrial release, and you'll be free to go.
Thank you, sir. Thank you.
Is that all you have? That's all you have, Mr. Head? Good to see you. Mr. Schmidt, you ready?
Yeah.
Who would you like to call first?
Thank you.
Who would you like to call first?
Cindy Head.
Sydney Hip, CR 22-379. Set for arraignment.
That's correct. You have received the indictment and wait for reason. Things spelled correctly. And that's for pretrial.
All right, court will enter Mr. Hip's plea of not guilty into the record. Court sets this matter for pretrial. Do you have a date that you're going to be back in February that you'll like, Mr.? All right, court sets Mr. Hip then for pretrial on February 7th. Mr. Hip, once you sign, get the yellow copy. Have you signed your conditions of pretrial release yet? Okay, I want you to check in with the pretrial release officer outside, Mr. Waddell, and make sure that you get your conditions signed. Once you do that, then you're free to go. Okay.
Judge, one that I have here. When we own, we're not been tested in pretrial, and then we may have this position.
Okay. And Mr. Fuller has not appeared. Nash Fuller, do you know?
No, I think,
Okay. And then Mr. Dittman wasn't here. I saw that he had the warrant outstanding.
no, we're good, but this man was involved.
Okay. Yeah. Ms. Brumlow, do you have something on the docket today?
What?
What's the defendant's name? Stefka. Okay. Okay. Oh, there you are. I didn't see you on there. All right. Is Mr. Stefka in the courtroom? All right, Mr. Stefka, this is CR 22-341. We're set for pretrial. Go ahead and make your announcement again, Ms. Brumlow.
DA's office. I believe we're gonna be able to reach an agreement. We're asking for a reset at a pre-trial date so that way we can come up with a further agreement and have the paperwork ready.
We're going to set it for plea.
Judge, we set up a docket call. Ms. Manuel has no pretrial. I have no doubt we will reach a resolution, but this week we can get moving forward.
Do you have any contested pretrial motions that we need to take up?
I think that we're gonna be able to reach an agreement. If we're not able to reach an agreement, we'd ask for a later date. case for pretrial with pretrial motion that is gonna be.
State would not be opposed to allowing leave to file additional pretrial motions. If that becomes necessary, I'm going to.
All right, court will find there are no pretrial motions on file at this time. The court will set Mr. Stefka then for a docket call. And then you can make an announcement at that time, whether you have a plea agreement or if you want a bench trial or a jury trial. I'm looking at either February 7th or 9th. Are you fine with either of those dates? Is that a purse within a purse?
First and second, and then we can do it.
Absolutely. Okay, let's let's go February 7th. So Mr. Stefka, you're ordered back on February 7th at 9 a.m. Have you signed your conditions of pretrial release with Mr. Waddell? You have. Okay, thank you, sir. Once you sign, okay, once you give that back to the pretrial release department and you get your yellow copy, you're free to go. Are you sitting by yourself in the corner? Okay. All right, Mr. Manning is on his way. And then, yes, thank you, Ms. Marlowe. All right, Mr. Murray Leader, you said you had a paper copy of your motion for continuance. You may.
We filed the electronic copy as part of 9. That's the unsworn copy. Sworn copy should be filed.
Okay. All right, can we get Mr. Waddell? Will you ask Mr. Waddell to step in? I know he may be busy, but. All right, this is cause number CR 21-143, State of Texas versus Christina Ross. The court is taking under consideration the defendant's fourth motion for continuance. Mr. Waddell, I'm sorry to bother you. I know that you're actively working outside, getting conditions of pretrial release taken care of with other defendants on the docket. With regard to your pretrial supervision of Ms. Ross. Ms. Ross has presented here. Let me show you the continuance. I want you to review that and then I'll give you a moment to review that. All right. When is the last time you saw Miss Ross in person? Over a year? And has she relayed any of these medical complaints to you?
Yes.
And how are you supervising her? Okay. Is she otherwise compliant with her pretrial release?
She's very delinquent, but she's communicated the struggle financially that she's had. First lost her job, and she went back to work. And now she's had some additional health problems.
Okay. Any other issue that you need to be brought, that you think needs to be brought to the court's attention regarding Ms. Ross before I decide on this continuance?
She's tried to be communicating with me in a reasonable fashion.
And she reports by phone? Okay, all right. Thank you, Ms. Waddell. Appreciate it. State, do you have a position on the defendant's fourth motion for continuance?
State really takes no position. I don't recall, I was trying to remember, I don't recall at the last setting, whether we indicated that future settings would be required to be in person.
I believe I instructed Ms. Ross that she had to be in person the next time, because at that time we knew that Mr. Ellison was taking a plea today and was resolving the case. And so I believe I told Ms. Ross at the last setting that she had to be here in person because I've let her report via Zoom pursuant to y'all's agreement for over a year.
Yes, Your Honor, we basically take no position. I mean, she has provided medical documentation. That's also on a consistent basis. So
Is this-
whatever the court feels is appropriate.
What's the state intending to do with its prosecution of Ms. Ross in light of Mr. Ellison's case being disposed?
Your Honor, there is one more co-defendant. We expect to also be at trial, that Ms. Ross's testimony could be very helpful, if not necessary for. So we anticipate that this is going to, we wouldn't resolve it today either way. Because there still is, another party that is awaiting trial. I believe he's in the top 10 on the rolling list, but not currently special set for
Mr. Merlier,
That's all correct, Your Honor, and I believe that Ms. Ross has been cooperative as far as accepting subpoena. The last time that we were set for her testimony in December, we accepted her subpoena to appear, and she was going to appear in December for Marcus Olson's trial. She had made plans to appear, and then the DA's office excused her, and I let her know. The last time she appeared in person in court was in November of 2021, when we waived her jury trial. So we're completely in cooperation right now. We're just in kind of in limbo as far as the case is concerned. That's why we're continuing to have status settings. We don't have an agreement with the state, but with the cooperation here that they've capped her offense and the third degree felony. But I don't know exactly what the after Hobson's case is finished, which may take until the summer. So, and we're going to make ourselves available to testify as well. And Ms. Ross, you know, I do not believe she's trying to purposely get out of the court's orders to appear in person. She did provide me the documents. I told her to be in person, and she provided me the documents for the PR settings. I understand that she's been delinquent with her payments, but she's had a whole slew of medical issues, and she is working now. And we respectfully ask for this.
you just grab that phone, Deputy Everett, and silence it, and you can. All right, the court is going to set Ms. Ross for Mr. Hobson, Ms. Heisel, Mr. Hobson, is he especially set for trial at all?
He's not on the roll list, but special setting for it to come open. I think we would request that he be special set, but right now.
All right,
The court is set for Monday's trial reflected, but number one, I think it's in the top 10, but it's not that.
all right, court's gonna set Miss Ross for status on February 21st. She must be in person that day.
Judge, I have a trial setting where I have one of the top 10 cases in Cherokee County that morning for jury selection. February 21st. Is there anything available on the 23rd at all?
No, what about March 7th or 9th?
Mine would work better.
All right, court will set Miss Ross for status on March 9th. Court is going to take a nice eye under advisement today. I'm gonna grant the continuance, but I'm going to take a nice eye under advisement until 5 or till, what time do y'all close tomorrow, Karen? 7? Ms. Burns,
Sorry.
what time do y'all close tomorrow? 7? Just tomorrow, Friday? What about Monday? 7? All right, court's gonna take a nice eye under advisement in the court. We'll take that under advisement until 7 PM on Monday. So she needs to report to her pretrial release officer in person on or before Monday at 7 PM, and they close at noon tomorrow.
If she provides the doctor's note, would you be able to?
Well, I've reviewed the doctor's note that she provided for today, but it says bronchitis and breathing issues. Doesn't say anything about being unable to travel, being unable to move. There's doctor's note, I don't think would be persuasive. I mean, I'm giving her till Monday to avoid being arrested. So I think that's more grace than she's probably entitled to. I mean, I've let her do this for a year, and I told her at the last setting to be here, and she didn't notify us until yesterday. So to be honest with you, to me, I think she is evading the court. That's just my opinion, but it seems like every court session, there's a request for Zoom and there's a doctor's note that follows it. So it's a pattern. And so I'm going to give her till Monday at 7 PM. If she doesn't check in with the probation pretrial release department, then the court's going to issue a warrant for arrest. Court is granting the continuance on the status hearing until March 9th. And just find that she hasn't appeared today as ordered.
Yes, sir.
Okay. Yes, thank you, Mr. Morgan. All right, so we're waiting on Mr. Manning, and then Judge Griffith will be here at 11, I believe. Let's see who else we can call here. Has Joshua Davis arrived yet? Joshua Davis? No. All right, Miss Anders, come on up. This is CR 22-351, State versus Katrina Anders. Ms. Anders, I believe that we had you on status to hire an attorney. Is that correct?
Yes, sir.
Tell me about that.
Well, I didn't understand all the information, just, I didn't read it right, I was nervous and everything, on the income. I haven't been in Baylor Hospital.
Okay, hang on. Did you fill out your,
Yes, sir.
okay, well, I tell you what, have a seat and I'll get with Ms. Abraham.
Good, what's the problem?
CR 22-351. Benjamin Miles. Benjamin Miles. Will you tell them that they can come in here and have a seat? I'm having to bellow out. We got room now. Are you Mr. Miles? Come on up, Mr. Miles. This is CR 22-381, State versus Benjamin Ray Miles. Mr. Miles, it appears that you have been indicted for the first-degree felony offense of manufacture or delivery of a controlled substance, penalty group 1. A first-degree felony carries a range of punishment of not less than 5 years in prison or more than 99 years or life in prison. Today, you are set for arraignment on that cause. Do you intend to hire an attorney to represent you? Have you requested court-appointed attorney? How do you want to proceed? Okay, have you already spoken to an attorney? Okay, who have you spoken with?
Robert Perkins.
Okay, and have you retained Mr. Perkins?
I have not, he was on vacation. I only spoken to this.
Okay, well, it's probably not good to wait till the last minute before you come before a judge. Should have, I mean, you've probably been aware that you were arrested quite some time ago, right?
Couple months ago.
A couple months ago, and you waited till the day before court to call a lawyer. I'm just saying it's not very wise. Do you agree? So what I'm going to do for you, Mr. Miles, is I'm going to give you a 30-day reset. And I want you to hire an attorney, whether it's Mr. Perkins or someone else. No, I want to see you again in 30 days. And if you've put a down payment or something, then we'll talk about that. That'll show me some good faith effort on your part, but I don't want to just reset you for 60 days because that would be 90 days that you've had knowledge of this. Okay.
Yes, sir.
All right. So is there a reset notice?
I have one.
Okay. So Mr. Miles, I'm going to reset you for February 7th. It'll be at 9 a.m. Deputy Everett's going to have you sign this notice of appearance. I'll tell you what, let me make some notes on here if you don't mind. All right, Mr. Miles, you're going to sign there on the X, and then we're going to give you a copy of it, and it's going to have your return date. And then, Mr. Miles, I want you to check in with Mr. Waddell with the pretrial release department. Ms. Abraham here will take you out there in just a moment. Those are conditions of pretrial release that are going to be attached to the bail that you posted in this case. So those are going to be conditions you have to comply with. And if you violate those, the court could find your bail to be insufficient and put you back in jail. It's going to say things like no drugs, no drinking, no alcohol, no new offenses, and you're going to have to report so I can verify all those things. Okay. All right. So hang on just a second. Okay. I'll recall.
Well, that's the one that's
Yeah.
been in my.
Yeah. She's still here?
I don't know.
Probably not. I think he took off.
Okay, well, Jonathan's coming. I'll ask Jonathan to indict it. I mean, to arraign it.
Okay. So you're still working on sides. All right, go with Miss Abraham. She's going to take you to Mr. Waddell, and then you'll do your pretrial. I'm sorry, Karen, I could have asked you to do that, but go with Miss Abraham there. Joshua Davis, come on up here this way. There you go. This is CR 22-372. State versus Joshua Lee Davis. Mr. Davis, you've been indicted for manufacture or delivery of a controlled substance, penalty group 1, 4 grams to 200 grams, a first-degree felony, has a range of punishment of not less than 5 years in prison or more than 99 years or a life in prison. Do you intend to hire an attorney to represent you? Okay, and have you started that process? Next 2 weeks. So if I set you out at least 2 weeks, you'll be able to take care of that. All right, so I'm going to give you till February 7th. This is CR 22-372. So I'm gonna expect you to come back with your lawyer, okay, whether it's Mr. Davis or someone else, all right? If you and Mr. Davis don't work out, I don't want you to come back and tell me you need time to talk to another one. All right, and have you checked in with the pretrial release department yet? All right, so you're gonna sign this, you can get the yellow copy, and then Miss Burns here will take you out to Mr. Waddell. You'll need to sign conditions of pretrial release. Thank you, sir. Eugenio Gonzalez Merlo, come on up.
Just said Mullins is here.
See a Mullins, but Tillo, Sykes, Tune, Barnes. Let's see one.
Talk to Patty.
Yeah. Find out. All right, Mr. Gonzalez, this is CR 22-374-375. You've been indicted with 2 offenses. The first, evading arrest or detention with a vehicle. That's a 3rd-degree felony, range of punishment, not less than 2 years in prison, not more than 10 years in prison. And also theft of property greater than $30,000 in value, less than $150,000 in value, also 3rd-degree felony, same range of punishment. Do you intend to hire an attorney to represent you on these matters? Okay, and when can you have that attorney hired? In a week or so? All right. All right, I'll tell you what, I'm gonna give you a little more than a week. I'm gonna set you on February 7th. And I expect you to come back with your attorney, okay? I'm gonna have some paperwork here for you to fill out. Hey Karen, will you get me a notice of settings so I can fill that out, or can you give me a couple, just leave me a couple of them here. I might need a pen. Do you have a good pen? I need something on this one. Mr. Gonzalez, do you have any difficulty with the English language? Do you need a translator at all?
Yes.
You do? Need a translator?
She's gonna be Julie Mullins.
Okay.
She's here.
So it was not Mullins, it was just, that's what I heard, okay. All right, Mr. Gonzalez, I'm gonna have you sign right here, and then I'm gonna give you a copy of this, says that you're coming back on February 7th with your attorney, okay? Ms. Jones? Jasmine Jones? All right, Ms. Jones, this is just a probation extension today. Appears that you're wanting the court to extend your community supervision period for 1 year. That would extend you until January 6th of 2024. As part of that extension, the probation department is asking that your probation fees be waived, your analysis fees be waived. Why is it that we need an extra year on your probation?
To get a job, and to get everything, and I didn't wanna make a commitment to do my classes, and I didn't have my end of the bargain all set, so. It's kind of took me, I just got a job last month, so,
Feel like you're doing better
yes, sir.
on your feet now? Okay, well, apparently the probation department doesn't have any more concerns with you, or they would have told me, so I'm going to approve your extension for a period of 1 year so that you can do your classes and get off of probation and get us out of your life. That's what you want, right?
Yes.
Okay. Is Jordan Patillo here? Jordan Patillo. Julie Polans. All right, CR 22-361, State versus Julie Lutz Polans. Ms. Polans, I had you set to hire an attorney today.
Yes, I tried that. I was talking to this year, but I also got looking to keep my. Hey, I don't know. The friend was lady, I was supposed to be, I was on my way to work and my boss was talking to me, I was supposed to be before. And I so apologize for not being dressed and ready, but I was on my way to work and my lady I work for is the sister to the manager. I was gonna have for my attorney,
Who is that?
Robert Perkins.
And so have you already spoken with Mr. Perkins?
I spoke to him, but he hasn't called me back, and I thought he should be with by now.
When did you speak with Mr. Perkins?
Probably about 3 weeks ago.
Did you speak with him in his office? or-
Yes,
Okay,
I haven't wanted it yet.
and so he's already told you how much
He
money?
didn't tell me anything, he didn't call me back.
Well, I thought you said you met with him.
I did, he said he can give me,
Did you talk to him about your case?
yes.
And he didn't tell you how much to hire him? All right, Ms. Polans, what I'm gonna do is I'm gonna reset your case. I'm gonna reset your case for arraignment and status to hire an attorney until January 24th.
Thank you.
And if you don't hire Mr. Perkins, then you need to make arrangements to hire someone else. Okay, so when you come back on the 24th, you need to have a lawyer with you. Or our hearing is gonna be a lot different on that day. And Ms. Polans, are you on conditions of pretrial release yet?
I pay $10.
Okay, so you meet with your pretrial release officer and do all that, Mr. Waddell? Okay, all right, you're free to go. We'll see you back on the 24th. Is Carrie Sanders here? Carrie Sanders? All right, and for the record, CR 2231. The court had Miss Savannah Michelle Toon set for sanctions status hearing today. Court has signed a motion to adjudicate. She was taken into custody by Investigator Morrison with the DA's office this morning, I believe. So we'll wait and set that for. Tell you what, we'll go ahead and set that for a motion to adjudicate on 1/26. Right, and those of you who have Mr. Manning as an attorney, raise your hand. Okay, he's on his way. He's running late, but he's on his way. And then everyone else, I should have already called your case. Anyone else that's in here and not called your case? Oh, yes, and so I've got your paperwork right here, it looks like. Okay, good. All right, so we're gonna wait for Mr. Manning to get here, and then we'll call the rest of the cases, including yours, Ms. Sipes, okay? Is there anyone else? I've not called your name and or you're not represented by Mr. Manning? Okay, yes, all right, Noe, is it Noe? Let's see. And have you talked with Mr. Schmidt today? Okay, all right, so he must still be here, and so we'll call your case here in a moment, okay? Anyone else? Not called your name, you're not represented by Mr. Manning, and your last name is not Sipes. Anybody else? Okay. All right, court's going to stand in recess to give Mr. Manning time to get here, and then we'll call the rest of the cases. Ms. Burr. All right, we are back on the record and the court calls cause number CR 21-153, 156, 179, State versus Tyler Elizabeth McInnes. Ms. McInnes, if you'll come forward, Mr. Sanders. Mr. Sanders, this will be a plea today, is that correct?
Yes, sir, that's correct.
All right, you are Tyler Elizabeth McInnes, is that correct? Ms. McInnes, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. Just speak up loudly and clearly for me so we can make a record. Ms. McInnes, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with any type of mental condition? In this case, you are represented by your attorney, Mr. Jeff Sanders. Are you pleased with him as your attorney? Do you feel like you've had enough time to talk with him about your cases so that you've had all of your legal questions answered? Is there anything about the paperwork that you've read over and signed today with regard to your plea agreement that you do not understand? Mr. Sanders, do you believe your client to be competent today?
Yes, sir, I believe she is.
And have you explained to her her rights as they pertain to each case and also the advantages and disadvantages of a deferred adjudication plea?
Yes, sir, I believe we've gone over all those things.
And you believe that she's intentionally and knowingly waiving rights today within this plea agreement?
Yes, sir.
All right, Ms. McInnes, in cause number CR 21-153, you are charged by information with a misdemeanor offense of driving while intoxicated, a second offense. That is a Class A misdemeanor, which carries a potential range of punishment of up to 365 days confinement in the county jail and a fine which cannot exceed $4,000. I see the plea agreement in that case is that you would plead guilty to that charge. The state's recommending your sentence be set at 61 days confinement in the county jail, with you receiving credit for all 61 days, that you pay a $100 fine plus court costs and reimbursement fees. In your other case, CR 21-179, you are charged by indictment with assault of a peace officer, a second-degree felony, which carries a range of punishment of not less than 2 years in prison or more than 20 years in prison and a fine not to exceed $10,000. I see the agreement is that you would plead guilty to that charge. The state would be recommending that the court not convict you today, but rather take it under advisement and defer a finding of guilt and place you on community supervision for 10 years. In addition, you would have to pay a $1,400 fine plus court costs and reimbursement fees. Is that your understanding of the plea agreement? There's also CR 21-156, which the state would be dismissing today upon your plea of guilt to that and taking it into consideration. And that charge is fail to ID fugitive from justice, a Class B misdemeanor. So understanding the range of punishment, understanding the plea agreement, you understand also, Ms. McInnes, that if the court approves the agreement today and places you on community supervision deferred, you understand that if you violate any of the conditions of your community supervision, the state could file a motion to adjudicate your guilt. That means to convict you, could bring you back before this court, ask the court to conduct a hearing, and if they put on evidence that proves to me that you violated your community supervision, the court could do several things, including the court could convict you of the second-degree felony offense of assault of a peace officer. The court could revoke your community supervision, and the court could sentence you anywhere between the minimum 2 years up to the maximum 20 years in prison. You understand that? And you still wish to go forward? All right, Ms. McInnes, at this time, how do you plead to driving while intoxicated, a second offense, a Class A misdemeanor? How do you plead to assault of a peace officer, second-degree felony? Are you pleading guilty to each one of those crimes because you are guilty of committing each crime? Has anyone threatened, forced, or pressured you to plead guilty to either crime today? The court will accept the defendant's plea of guilt in each cause. Mr. Sanders, is there any objection to the state's evidence supporting the plea?
No, no objection.
The state's evidence is admitted as State's Exhibit 1 in each case respectively, and the court does take judicial notice of the defendant's judicial confession. Is there a victim compliance on behalf of the state?
Judge, the trooper is aware of our resolution. He is supportive. I spoke with him before our previous setting where I thought we were going to family. Mr. Standard would say something of that nature, but he is supportive. He understands what's going on. He's okay.
All right, thank you, Mr. White. Anything further from the defense?
Judge, the only thing I would bring up regarding the DWI, because even though this happened in June of 2021, I think there was still the potential for the super fine to be assessed on a jail sentence. Just out of an abundance of caution, I was going to ask the court would make a finding that Ms. McInnes is indigent. She had been in the Gray County Jail on charge over there from June 11th through November 2nd. So obviously hadn't been working there, hadn't earned any money there. And then since being released in November from Gray County Jail, she's in the process of trying to find employment, but doesn't have a job yet. So we would just ask for a finding of indigency as it would pertain to the potential assessment of a super fine by the state.
And by super fine, are you asking me to waive the fines and court costs today?
No, Judge, just on the DWIs, whenever it's a jail sentence on misdemeanor DWIs, there's the state can assess a fine, basically taking the place of surcharges. And I believe on a DWI second, it could be up to $6,000 unless there's a finding of indigence. So that would just apply to not to any fines of court costs assessed by the court on these cases, but just to basically what used to be a surcharge.
So you're worried about the Texas Department of Public Safety in an ALR hearing at a later date?
Right, as far as potentially, and she understands that with her license, I don't think is in good standing right now anyway, but this would suspend her license, but the state can also go through and assess additional fine along with that, so unless they're finding it indigence, so that's why I was asking.
Well, I believe the court has already found Ms. McInnes to be indigent, and that's how she's received you as counsel. And so the court has already found Ms. McInnes to be indigent and has appointed counsel for that purpose. Will that finding suffice? That's a
And I
record.
think it might, Judge, I guess you never really know when it comes to DPS and the state when it comes to driver's license, but I mean, I think that, yeah, there's already been a finding of indigency for that purpose anyway.
So they would have no objection to you finding her continuing to be indigent.
Well, I think I want to hear about that. I mean, you've told me, but I haven't taken any sworn testimony on that. I don't know about her efforts to make money, to get a job, to not get a job. Do you want to put her on for that purpose? All right, and you understand you're under oath for your testimony. All right.
And Tyler, I think we talked about this a little bit, but as far as your financial situation right now, first of all, you were in the Gray County Jail, I believe, June of 2021 until November 2nd of 2022. Is that correct? Because you had charges, you were being held on the felony from Defendant County, but you also had charges pending in Gray County. Is that correct? And all those cases are now resolved. You're on probation at Gray County. Is that correct? Okay. Obviously, during that time period of about 16 or 17 months, you weren't working, you weren't earning any money. Is that correct? Okay. Yeah, since you've been out of Gray County Jail and from early November, have you been able to get a job to this point?
Not yet, but I am.
Okay. And is that something that, well, just as far as doing probation here or in Gray County, talked about how the need for you to get employed and get some income because there are financial obligations you have for these different probations. And so you understand that's something you need to do, but you don't have a job at this time. Okay. So as far as you haven't made any money over the past year and a half, is that fair to say? Okay.
We have no question, Your Honor.
All right, Ms. McInnes, can you tell me what kind of employment you had before you went into jail? What kind of employment you're seeking now? Do you have any qualifications, skills, anything that has hindered you or enabled you to find employment or not find employment? Can you tell me about that?
I was just serving for a long time, customer service. I did work at Avon as a brazen for a period of time. Then I didn't go to jail, so. Lost.
What kind of jobs have you been looking for since getting out of jail?
I'm looking at, metal fabrication. Starting jobs, anything that I can go get.
And you haven't found any jobs? And like, where have you applied?
Metal fabricators. Owning and Zero, just the warehouse. Applied at Amazon warehouse.
What,
There's-
what about serving jobs?
On top of that, gonna have to apply. I've applied at like Texas Roadhouse. Barrel. There's a bunch of other jobs like in between. No one's else.
Right. Anything further, Mr. Sanders? Okay. All right, court is going to review the evidence. All right, court has reviewed the evidence. I find that there is sufficient evidence to convict Ms. McInnes of each one of these offenses. The court will follow a plea agreement reached between the defense and the state. In regard to driving while intoxicated, second offense, class A misdemeanor. Court hereby convicts Tyler Elizabeth McInnes of that offense, assesses her punishment at 61 days confinement in the county jail. Court awards her 61 days credit for time previously served. Court orders her to pay a $100 fine, $270 court cost, and $85 reimbursement fees. With regard to assault of a peace officer, CR 21-179, second degree felony, the court hereby defers a finding of guilt, places Ms. McInnes on 10 years community supervision. Orders her to pay a $1,400 fine, $290 court cost, $990 reimbursement fees. The court dismisses under section 1245, DA 2021-485, driving with previous conviction, driving while licensed invalid previous conviction, and also dismisses under section 1245 CR 21156, failed to ID fugitive from justice. Court orders her to also pay court costs of $290 and reimbursement fees of $990, if I haven't mentioned that. Court finds that Tyler Elizabeth McInnes has been found by this court to be indigent for the purposes of the appointment of counsel under the Sixth Amendment to the United States Constitution, and the court also finds that she remains indigent at this time with regards to fines, court costs, reimbursement fees. Court finds that that could change and that Ms. McInnes is on community supervision for the next decade. Court, let's see, Ms. McInnes. So Ms. McInnes, when I read through this offense report, I think the trooper could have a completely different opinion of you and whether or not he agreed to this kind of resolution for you. Have you read through this report? Do you remember this night? Yeah, I would say that's the least, probably the least offensive adjective I could think of. You said some pretty vile things to him and racial slurs. And how intoxicated were you that night?
A day, for that. Had a lot of time to sit and think about it. I'm definitely not.
And were you, how were you intoxicated? What were you on that night? What kind of alcohol? It's a good thing that the officer was called out to take you to jail, because you could have lost your life that night.
Yeah, I think about that a lot.
Yeah, or worse, could have killed someone else. Well, in all of your thinking, I hope that you think that maybe writing a letter of apology to this officer for all the nasty things you said to him, I hope that you would think about that and do that and send that to him. Might make a difference in his life. Well, I'd probably do more than think about it. I'd probably do it. All right, the court hereby remands Tyler Elizabeth McInnes to the custody of the Van Zandt County Community Supervision and Correction Department so they can carry out the terms and conditions of the sentence. Ms. McInnes, I'm gonna have you come forward with Deputy Everett. He's gonna take your fingerprint. After that time, you're gonna report to Ms. Burns, and she'll give you more information about your probation. Yeah. What you got? Page 6. Custody. Hey, will you check pretrial credits on that money wise? See if they pay anything. See what they're doing. Okay, well, we haven't called that yet, so we will. Mr. Schmidt, I believe that Ms. Tabraham appointed you to Katrina Anders. All right, okay. Ms. Anders, if you'll come forward, Mr. Schmidt, CR 22-351, say versus Katrina Anders. Ms. Anders is charged by indictment with possession of controlled substance in penalty group 1, less than 1 gram of state jail felony. Court had reviewed her request for court-appointed attorney, finds her to be indigent at this time for the purpose of appointed counsel, and appointed the Honorable Richard Schmidt to represent Ms. Anders. Go ahead, Mr. Schmidt.
Good job. We received a copy of the indictment. Reviewed it, or is it all correctly, we laid it formally, or figured out.
All right, court will enter Ms. Anders' plea of not guilty into the record. We'll set this matter for pretrial. Do you want that February 7th or something a little further out since you just got appointed today?
Yeah, Miss Anders is resident of Louisiana, so.
You wanna do March 7th? The week after. Yeah, I mean, if you want to look right here, this is what I'm showing right here. This is Canon.
Oh, yeah, that's perfect. Okay.
Sure. All right, Ms. Anders, court sets you for pretrial hearing on March 7th. That will be at 9 a.m. and we should be upstairs in the courtroom by that time. Mr. Waddell, do you have Ms. Anders on conditions of pretrial release? She says yes. Okay. Okay. You're welcome. Is Mr. Manning here yet, or is he still, Mr. Manning, is he here yet?
Well, he's on his way, so. He's having to call him.
Is he in court soon?
He's in coffee. He's here. Is he here?
Oh, is he working? Okay. All right, I know that there you are, we're just talking about you. Noe Limon, I've seen the state's motion to dismiss. I was having pretrial release check with financial credits to see where we're at on that. Hey Patty. Is Judge Griffith here? He is, okay. Okay, I think I'm gonna step off, let him step on, and then gives Jonathan on the word. Mr. Manning.
No, they're not.
Do you need some time? Okay, I figured you would, so I'm gonna step off, let Judge Griffith step on. Don't have to, so I'm gonna stand in recess until they're ready. He needs time.
Yeah. I'll let you know.
Okay, all right, court's gonna stand in recess.
One twenty.
Let's go back here.
I know it's really good that email, but I'm not sure.
Sorry. My wife is trying to figure out what she's doing where to begin.
Surgery.
Oh, it is.
It's see the one, please.
Yes, my son is 39, so there's a new party he wants to set up.
Stephanie's waiting on court costs, on the newly filed case. We have the food packet for the other one, so we're just waiting on the judgment, and the judgment.
See information.
Information on the other one.
Yeah. my line.
Okay, they're still waiting on court costs.
She was. Here.
Yeah. On the wire, it's not- Stephanie said she's.
Yeah, please. Next Tuesday.
But I think they did know that they did.
Yeah, here's your two. Thanks, sir.
It's really nice. This technology is like.
Which programs?
They call it.
I haven't been over yet, I'm really excited. You. And it's very emotional.
That's awesome.
And I thought I did again.
That's great.
Yeah, when we walk in the courtroom, the podiums are this big, and they're all wired up for set and like.
The council table was that, you know, like from where the bench is here, council table way back there, like you have a huge well.
Yeah.
Huge.
It's on the fabric, Coffee County's new courthouses.
So someone took on the Huntington sewer, and then Rhonda, the district court.
She is crazy, she's awesome.
She's so awesome. But she was ready to actually showing off like a problem, all of it. They have. Space to grow, they have all the archives there, they have a break room that's huge.
Yeah, the DA's office has like, well, they had to go to the court.
And how far away is it?
Well, we were, okay, you're in the second, but then that's the four.
I didn't know that's here.
It's huge.
I haven't heard that.
Why?
Yes,
No.
they are doing that, they don't have an office. They're looking at the fact that those parties that are more to each other kind of thing. And I think like, she has their own, I think it's just kind of like, one of the new things they're having. Once that was in and they figure it out.
Oh, wait, and that's back to the committee wrong. It's a hot under my hands. It's on the information.
Oh.
They were, we saw it.
If I have to, over here.
Thank you. Yeah. It's not, I didn't file it yet. I was waiting for a copy. Yeah. So,
Hey, sure. Go ahead. But the stipulations are in, we're doing the discovery, we're gonna have a long process.
Yeah, he's filing information for money laundering, to state, you know, just wanna prepare all this individual. Administrative money laundering, I guess, not at 3G. Dealer. Great. Let's see if you roll down. I told them. That's all I have to do. That's nothing. It's fine. No, of course, it's emailing.
Yeah.
Is comment not on share before?
If we have it, it's in the.
I didn't see.
Not in here.
Yeah, I didn't see. And I emailed something about it.
No, you probably.
He's not gonna do that.
It's probably not good.
That's a different one. He's gonna do mental health addiction regardless. And it's. So there's no.
I'll send you back on Tuesday. Of this week. Start with last 10 minutes. Because we're taking files back up. I'm there. Okay. So I don't think they were there.
Just got it.
There. There. Yeah. Yeah, you know, they're on that meets.
Sitting in line. I'm sure. So very good song, hey, you're not song. No. He said, he just got to come back at 7 o'clock. Let's get it done. Yeah. So it was a week-year vacation for the area. And so we were kind of for a while. Thank you. Give us science. Okay.
That's what Janelle.
Oh, yeah, maybe it's- That's. And this one has to be, so I was, whenever we were doing any of this, we had some polling where it's one. And we did it's, we could spend with three polling, the side of the play whatever. And but. Okay. One second.
Yeah, you go on the group. You know, you can go on the road, and everyone wants you like this car, yeah.
If you need to get one, do it sooner than later.
Oh, he's good, he just.
Oh. I was gonna say. It's expensive to expedite, it's still not very fast. Not in there. Oh, really? Mhm. Let's see that. Those are- Right, it's-
Show up, show up.
Yeah. it's in the weird one.
Yeah. Personally, I would like to. Have you ever been in Orlando? It's super fun. They have like bingo every day. And the prize for the bingo, for like dolphin tours and, yeah, it's fun.
It's great.
And it's fun. It's a chill. But all the weather good.
And the information is actually filed, right?
Yes.
Great.
And there's a copy of it in the back of the playback.
Fantastic, thank you.
So first file, constant review. All right, here. Feel your eyes. I'm sorry. I was as I can. It's consistent with justice. Yeah. Okay, it's gonna take me. I'm trying to get my thoughts organized. Like, or case notes.
Right.
Everybody.
Yeah.
And I don't think you can say. You can sign this one. It may take a few minutes. That's what you're saying. Okay. If you choose to accept that, you're gonna get a waiver and reason. I'm out there, I don't know the temperature is.
think we're good with whatever.
Okay. Yeah. If he wants what I can do in one, but.
So much for the offer, I just feel like all else on your rear efforts, like. Nice meeting you. Ladies. What are the things that you're trying to say?
Mr. Manning, are you ready? You can sit down, thank you.
Mr. Turner, Mr. Barnes, out first, with some donuts.
Oh, yeah, sure. You know what, Patty, may I borrow your docket? I think I took mine upstairs. Hey, we go get mine off the credenza. Hey, listen, it's not on the credenza. It's in my office on that credenza. Jason Lee Barnes, CR 22-201. All right, Mr. Barnes is set for pretrial. Go ahead, Mr. Manning.
Yes, Judge. We've had an opportunity to review the evidence in this case. We have a pretrial evidence at this point. We request the opportunity to raise any if they come available, and request to be set by file.
All right, court will grant leave to file pretrial motions late. Court will set Mr. Barnes for a docket call. It's 30 days sufficient time, Mr. Manning.
Yes, Judge. And Judge, just to inform the court, I am working on, we have a tentative plea with the state that's needing to be shown through medical documents. Been trying to get those, but through the holidays, HIPAA and all that stuff, it should take a little longer. But I believe we should have 30 days should be sufficient.
Okay. All right, court will set Mr. Barnes for docket call on February 9th. And that'll be at 9 AM. Hope to be back upstairs, Mr. Manning, but we'll let you know.
Yes, Judge.
What was your other client's name?
Mr.
Turner, Rudy Turner, yes. Here you go, Patty. Thank you. Let me write here. There you go. All right, Ms. Turner, this is CR 21-400 state versus Brittany Turner, set for pretrial. Go ahead, Mr. Manning.
Yes, Judge. We've set a couple settings now for use CPS records. I believe we've reached an agreement with the state when requesting set for.
All right, you with the same February 9th?
Yes, Judge.
All right,
Is it Thursday?
Thursday. Court sets Ms. Turner for a plea on February 9th at 9 AM. I'm not sure what the plea would be, but I do want, she has a delinquency on pretrial release. Ms. Turner, have you made any payments to your pretrial release officer? Say again?
I said, I'll go next to the part back.
Okay, well, you're delinquent 300, so I want that taken care of before we move forward and assess anything else. Okay,
And Judge, just with footnote, Ms. Turner has been dealing with some health issues related to her hearing imbalance. So she's been in the hospital quite a bit recently. So we'll see, hopefully she's not in the hospital, she'll be something.
okay. Who next, Mr. Manning?
Judge, we can do Mr. Tupper.
Hunter Tapper, CR 23-7-1-34, CR 22-342, motion to revoke in pretrial.
Yes, Judge. I have had the opportunity to review things necessary. I've also spoken to the state yesterday. We received a new offer to resolve all the cases. I would request, I guess, one additional on the cases, so I can speak my mind about the officer that made. But I think we'll be able to resolve, like I said, both of the cases.
Any objection? All right, court will set Mr. Tapper then for the motion to revoke and docket call on February 9th. That'll be at 9 AM. You're welcome.
Mr. Baird,
John Baird. John Larry Baird. Okay, I had you as not here earlier. Maybe that was my mistake. All right, Mr. Baird is set for status, competency evaluation.
he was found competent. We have reached an agreement with the state, that actually resulted in him being released from jail, before the. The plan was to meet him today, but my understanding was the paperwork wasn't prepared. That was actually, my fault. And so there was miscommunication between myself and this already. And so we request a short reset to next Tuesday. So you can, we have covered some.
All right, court will set Mr. Baird then to enter a plea before the court on February 10th.
Judge, is that January 10th?
I'm sorry, yes, January 10th. Looking at the wrong day. Next Tuesday, January 10th. Should be in this courtroom too.
And then I've also had Mr. Baird, pretrial release, as he wasn't legally on condition to pretrial release by the US.
Thank you, Mr. Manning.
Mr. LeBron,
Mr. Lejean. This is CR 21-402, State versus John William Lejean Jr. Go ahead.
Judge, this is our final phone call. We'd like to announce that we have accepted the plea and we'll pass our fees.
All right, do you want next week one or a little bit longer?
If we can set for February 9th, Judge, he's still dealing with some medical issues. And he is in a better place to hopefully get those resolved before he goes. Takes this.
All right, and will it be for time or probation?
The current offer is 40 years, Judge.
Time. All right, so court will set Mr. Lejean to enter his plea before the court on February 9th at 1:30, Mr. Lejean, and it'll be out at the Justice Center. No, at the jail. You're gonna go into custody that day, February 9th? Is that what you are telling me?
Yes, Judge. So.
Is there any confusion about the proposed plea and scheduling, Mr. Manning? Seems like Mr. Lejean is.
Yes, Judge. Mr. LeBron is still wanting me to continue working on his behalf to, he has some mitigation evidence for me to review. I told him that by, setting for a plea that may be capped on the state, they said that they're the best offer. But he's still wanting me to bring some mitigation to the state, based on some recent stuff that he's talked about.
Okay, so we'll keep the setting February 9th at 1:30. And if something changes between now and then, you'll let me know.
Yes, Judge. If you recall, Judge, Mr. LeJean is dealing with some health issues. We would reset it to today, for him to be able to get surgery, and insurance. Unfortunately, they're not, come through to be able to do that, so that's what we're talking about. Seeing if surgery will be able to happen for them.
Just keep the court apprised then.
Thank you, Judge.
All right, you're free to go.
Judge, I believe that leaves Ms. Sykes. I was disappointed for her case this morning. If I may have just want to review.
Yes, sir, absolutely.
Indictments, then I was ready to waive.
It's Judge Whippets. Hey, Brian, let's go ahead and use this opportunity to call those nice eyes. So that in federal custody in Seagoville, yeah. So Kenneth Nash. We'll take him off. So I'm sorry, not Kenneth Nash, Nash Fuller. Nash Fuller, yeah, CR 2266. Court will Let's make a record of that real quick. Ms. Grisham, top of page 6. Nash Fuller, CR 2266. The court originally called his name, was not here. Court indicated it was going to issue a judgment nisi. Court finds that information has been provided that Mr. Fuller is in federal custody in Seagoville. Court's going to reset the arraignment to February 7th. And allow the state and Mr. Schmidt to work on that, determine the state wants continuous prosecution. Did he say he filed a waiver arraignment on Treasure Holic?
Good, no response, but. Mr. Manning said that he filed a waiver of arraignment on,
Holic?
yes.
Was that one that was in that list yesterday? Maybe. Yes, we need to call Christina Ross. Yeah, I don't see a waiver in e-file on CR 22-380. I'll make sure that it didn't get pulled directly into the clerk's file. Thank you, sir. I don't see a waiver filed on Ms. Treasure Holic, and there's nothing in the clerk's file for like a direct pull in. I have to ask Mr. Manning when he filed that. All right, so Deputy Everett, there was no response for Carrie Sanders, Treasure Holic, or Christina Ross.
That's correct, Your Honor.
Yeah, I'm gonna go ahead and do the nod side and then just take it under advisement. All right, yeah, that's one. Are you ready on Ms. Sipes?
Yes, Judge. Ms. Sipes, we have gone over her indictment. She understands the part against her right of punishment. They is spelled correctly and thus that we've accepted your trial. Her plea is not guilty.
All right, the court finds in CR 22-394 State versus Kristen Lee Sipes that she is indigent for purposes of appointed counsel. Court has appointed Honorable Jonathan Manning to represent Ms. Sipes. The court finds that she waives the formal requirements of arraignment. The court will enter her plea of not guilty into the record. Court sets Ms. Sipes for pretrial hearing. You want that February 9th thing? February 9th at 9 a.m. Ms. Sipes, have you already gone over your pretrial release with? Okay, good. All right, so once you get that yellow copy and then meet with Mr. Waddell outside, then you'll be free to go. Okay. Mhm. All right. Court has called Carrie Lynn Sanders, CR 22-392, no response. Court has also called Christina Maria Ross, CR 21-143. Ms. Ross was not present in court today as ordered. Court is issuing a judgment nisi for Carrie Lynn Sanders. The court is taking a nisi under advisement for Christina Maria Ross until Monday. Yeah, what's the date though? Monday, January 9th at 7 PM. And Mr. Manning, what was the,
Judge, Ms. Pollock spoke to Carl Waddell when she was checking out the pretrial, and he explained to her the process of doing away from payment. I sent that to her on Tuesday. She returned a copy on Tuesday evening. I was unable to open. I emailed her back Wednesday morning. She sent me something this morning that I have yet to open. But I believe I have a waiver requesting the February 9th pre-trial date. I just haven't had a chance to get that in to the file. She said it's morning at 7:45.
all right, court will, the court has called Treasurer Dory Hollick's name. She's not present in the courtroom. Court will set Ms. Hollick for arraignment and pretrial on February 9th, and we'll take an eyesight under advisement until February 9th at 9 AM.
Thank you, Judge. And did the court get the waiver or the Mr. Cotton? Okay.
Yes.
All right, Mr. Manning, so that concludes your business on the morning docket, correct?
I believe the judge, I have 3 pleas of that afternoon. And then one will be reset for a plea.
Who's gonna plead this afternoon?
Mr. Bird,
Bird, okay.
Mr. Logan. And Mr. McKibben.
Thank you, sir.
And like I said, I apologize on Mr. Bear. I assumed that Mr. Curry had forwarded that information to this out.
It's okay.
Did follow on that.
It's okay.
Yeah.
I pulled a Chris Mark. I had typed it in emails and then set checking, and it was left in my
Out
draft.
in your draft box. I've done that many a time,
Yeah,
many a time. It's a bad feeling, isn't it?
it's a pretty. Yeah.
All right, I'm gonna step off the bench and let Judge Griffith resume on the next case.
I know.
294th will resume its afternoon docket with the inmates at 1:30. Yes, I'm sorry. And for the record, Mr. Noe Lamone, the state has tendered a motion to dismiss. The court had Mr. Lamone pay his payment towards his pretrial supervision deficiency, not in full, but in part. And the court has granted the state's motion to dismiss, and Mr. Lamone has been let go. I'm gonna come off of the top, ring here and
There you go. Tag. Everything going well, you sir? We are on.
And he said, and I think that yeah, and I got back in there and I know, it's, I appreciate you.
Marcus, he's on the bench function here, I see. Right here. The only, there is one of his, Marcus, he said, I will also put that on the record. That's okay.
Is the judgment still correctly?
It's not still correct, if you want to read that, do it.
Yes, the judgment is correct, and since this is two, people have to reprint.
Okay.
I mean, we can proceed with the plea, check with the vote, just after the court start review, we'll need to have a new.
There's just a one letter typo in his name on the judgment, so we'll get that corrected. Otherwise, I think everything else is fine.
You have it as
Yes. Welcome back to Canton, Judge.
Thank you so very much. I'm sorry, y'all are waiting on me. I'm sorry.
No, you're fine.
Y'all may be seated.
Thank you so much.
I'm sorry. I'm looking at the documents and all of a sudden realize everybody's waiting on me. I'm sorry. Don't mean impose on y'all. Are we ready to proceed? We call calls number CR 23-0001, the state of Texas versus Marcus LaTroy Ellison. State's announcement.
Stage ready procedure on.
We're ready to proceed, Judge.
Thank you so very much, sir. I'm looking at this. We call that case CR 23-0001. I'm looking at the thing and this is pleading to a lesser included or something else. Is that correct?
Judge, essentially what it is, Mr. Ellison had a file charge that was being 1245. And information was filed this morning for a money laundering, 2,500 or less than 30,000. It is being enhanced by 2 prior federal convictions, which gives us the range of punishment of 2 to 20 of the habitual state jail, which is how we're able to plead him to 12.
So state jail felony, but it's going to be because of enhancements, it becomes PDC.
Yes, sir.
Okay. Let's see what we got here then. Okay. Mr. Ellison, would you stand up and raise your right hand to be sworn? Do you solemnly swear? I tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you so much. You may be seated. Sir, is your name Marcus LaTroy Ellison, MARCOS LATROY Ellison, ELLISON?
So that's what they're fixing on judgment. It's MARCUS, but otherwise that's the name.
We are the name corrected, just correct spelling.
Okay. Do you have any objection to them making that correction on the judgment to get your name spelled correctly?
No, sir, I don't.
Okay. Then I'll approve that change. MARCUS.
Yes, sir.
Okay. Now, this is we were here earlier, well, when we were here last time before Christmas, you were looking at a first degree felony enhanced 2 times, is that correct?
It had not been, so there were no enhancements in the indictment, but it could have been enhanced to 25 to life with Brooks.
Okay, and that was for looks like a organized, conspiracy to organized crime and possession and drugs.
Yes, Your Honor.
And-
It's kind of a complicated situation, so I appreciate it.
That's fine. You understand what you were charged with, right, sir?
Yes,
Do you understand that your lawyer has and the state has agreed to you to plead something differently? Is that correct?
yes, sir.
Okay. And it seems that instead of the conspiracy engaging in organized crime, what they're proceeding on today is a money laundering case of over $2,500 with less than $30,000, which is a state jail felon. Do you understand that?
Yes, sir.
They are, they don't. I mean, I don't want to jump the gun here. You understand you do have a right to a trial by jury, don't you?
Yes, sir.
You have a right to, against self-incrimination, right to confront the witnesses. You understand that?
Yes, sir, I understand.
Okay. You have you understand that by entering a plea of guilty, you're waiving those constitutional rights and
Yes, sir.
testifying against yourself in essence.
Yes, sir.
Okay. The now you haven't gotten a copy of the document. You understand the charges against you is now a money laundering charge, right?
Yes, sir, I understand.
Have you reviewed all this? I see your signature on all these pages. Is that your signature?
Yes, sir, that's my signature.
Now, did you go over it carefully with your lawyer to make sure that you understood everything they're doing?
Yes, he explained everything.
Okay, that's fine. He's a good lawyer. I'm sure he did, but I do want to put it on the record. So, but you understand what we're doing here, right?
I do understand.
Okay, you waived the right to a trial based on indictment. You're just going to go on information. Is that correct?
Yes, sir.
Okay. And the information is basically what is contained in the waiver thing. Is that kind of what you're going on?
There should be, Your Honor, just a copy of the information attached to the back of the packet.
I keep looking then. Okay.
They may have gotten trouble with you this morning upstairs.
That's fine. I can sit down. Don't stand up on my account. That's what I was looking for. Thank you for telling me that. Oh, here it is. Okay. Now, but you've agreed to waive the indictment, right?
Yes, sir.
Okay. And you understand what you're charged with, right? And the new information, as it were.
Yes, I understand.
Have you reviewed the information, what it says?
I did.
And you have any questions about it?
No, sir.
The next question is, sir, sir, do you understand that? Do you think he understands all the rights? You've gone over everything carefully with him?
Yes, sir. I believe he's confident.
And you think he's competent to enter into a plea today?
I do, Your Honor.
Okay. Sir, are you satisfied with your lawyer's representation and what he's done for you?
Very satisfied.
Okay, thank you. I would think so, but like a very good deal. Sir, Mr. Marcus with Troy Ellison. As to the charges in cause number 23-00001, in which you are charged with money laundering, a state jail felony, as well as 2 enhancements. As to that, how do you plead? Okay. And for the record, we're no longer really on CR 21-061, we're proceeding on the information provided the same gentleman, that's 23-0001. Sir, as to the charge of money laundering, the state jail felony, as alleged in the information, how do you plead? Okay, are you pleading guilty because you are guilty for no other reason? Are you pleading guilty because you are guilty but no other reason? Okay, if you have any questions, feel free to ask him. We're very casual here. You're pleading guilty because you are guilty. Okay, that's fine. And there is an agreed plea bargain in here somewhere. Is that correct?
There is, Judge.
Okay. Okay, this is money laundering, $2,500 to $30,000 under 34.02E1 of the penal code that occurred on July 8th, 2022. Under this new information, that is a habitual state jail felony with a range of 2 to 20 years and a fine up to $10,000. Is that right?
Yes, sir.
Okay. And you understand that?
Yes, sir.
I'm looking at the full range of punishment. I just told you understand what the full range of punishment is.
Yes, sir.
And you have a right to compel the witnesses and cross-examine the witnesses and accusers. You're entitled to be arraigned and have the charge read to you in open court. You understand that?
Yes, sir. I understand.
And you right to remain silent, a right to self-representation, a right to have a lawyer. Now, the lawyer has been, you've hired him for over 10 days, but we are now within 2 days, I guess, this morning, of new information. You know, you have a right for 10 days to prepare for this case on the new information.
Yes, I understand.
But you at this moment are giving up that right to the 10 days preparation.
Yes.
Okay.
You know that right.
And you understand that you're supposed to go ahead with that one today. Is that right?
Yes, sir.
Okay, doke. Okay, doke. You understand that if you're the recommendation, as I see here, is 12 years in TDCJ, Texas Department of Criminal Justice Institutional Division. Is that correct?
Yes, that's correct.
And there is a $2,500 fine. Is that correct?
Yes, sir. It is.
And you're requesting that this runs concurrently with any other federal time that might be out there.
Yes, sir.
I don't know about that, but evidently y'all do, so just in case.
Oh, sir.
Okay.
Thank you.
You understand that y'all's agreement is not binding on this court. I don't have to follow it. I can refuse it, and then you will, I'll let you withdraw your plea and we'll go to trial. You understand that?
Yes, sir.
If it doesn't, if the punishment doesn't exceed the punishment that y'all agreed to, then I'll give you permission to withdraw your plea. You're not a citizen of the United States. A plea of guilty nolo contendere can result in deportation, exclusion of permission, this country, or denial of naturalization. You understand that?
Yes, sir. I understand.
It's not a deferred. Now, I've looked at all these signatures, and that is all your signatures, right? I think I've covered that, but just in case.
Yes, sir.
It's kind of confused. I'm trying to maybe plowing the field twice. Better do it twice than miss anything. And as to I've asked you this, but just to be safe, as to the charge of money laundering, a state jail felony between $2,500 and $30,000, how do you plead?
Yeah.
Okay, then the court does accept your plea. The court has reviewed the plea bargain. I'm looking at the stipulation of evidence states exhibit 1. Is that your signature on the stipulation of evidence?
Yes, sir.
Okay. And they swore, the lady swore you too that this is true. So you understand
Yes.
that is the evidence plus your plea is the evidence before. You understand that?
Yes, sir.
Okay. The also the and part of this deal is that they want this I guess the conspiracy and all that, the manufacture delivery of controlled substance to be taken into consideration with your plea on the money laundering. Is that correct?
Yes, sir.
The old 1245 thing.
Yes, sir.
They changed so many of them. I kind of hate to quote them, but yes, and you want me to take it into consideration. And so basically they're blocked from prosecuting on that. You understand that?
Yes, sir. I understand.
And that's what you want me to do.
Yes, sir.
Sir, based on your plea and on the stipulation of evidence, then I do find you guilty of the charge of the money laundering. But and I also take into consideration the unadjudicated offense on this one thing about traveling around, every county has different forms. You got to go dig through it, so that's no problem. Sir, as to the enhancement paragraph number 1, I do need to ask that. How do you plead?
Guilty.
And as to the enhancement paragraph number 2, how do you plead?
Guilty.
Okay, and I find both of those true in consideration of your plea. Now, this is having found you guilty, is there any reason I should not impose sentence at this time?
No, Your Honor.
Is that your thinking?
Yes.
And just go ahead with it?
Yes.
Okay, then it is the order and judgment. I'm sure I got. The offer was 12 years and a $2,500 fine. Is that correct?
Yes, Your Honor.
And sir, it is order judgment in the period of this court that you be taken by the I sentence you to the 12 years in TDC J institutional vision. I sentence you to 12 years in order to pay a $2,500 fine. It is order judgment decree that this court that you be taken to the sheriff of this county, you be transferred to the authorized receiving agent of the Texas Department of Criminal Justice, where you should be confined for a period of 12 years. Your sentence will commence this day, and you'll be given credit for any time you've served on this case. So that sound good?
That's great.
Let me go through this and make sure I hit all of them. Yes, of course you may.
Replace the first 3 pages just to make sure we get the judgment on the correct spelling. And I believe everything else
Perfect.
will be. And just for the record, he does have on that front page, I believe it was 64 days credit towards his sentence.
Does that sound about right?
It is, Judge.
Okay, then I do get, there it is. I do give you credit for the 64 days. I do find you guilty of another enhancements to be true, sentence you to 12 years in prison. I'll sign this one as well, so we have it all. Got that one signed. And also, I'll point out, because this is, I have followed the plea bargain, you'll have no right to appeal. You understand that?
Yes, sir.
This is kind of where you're at. Okay, then okay. Thank you for getting that correction. I'd written it in, but it's even better.
Mr. J. Brown upon us, making those changes.
I know, that's,
Okay, so
it's better to
if
get,
I'm mistaken, sorry.
get our ducks in a line, so we don't have to come back and do this whole thing again. It says here that, court cost fees and fines and restitution are now $2,825. You understand that?
Yes, sir, I understand.
It takes a while to dig through every page in here and make sure I haven't missed something. The back part seems to be the discovery.
Yes, sir.
Now, I should ask you, sir, that y'all got all the discovery you needed, right?
We did, Judge.
You know, after,
There was quite a rolling discovery process, including statements as far back as maybe April, March last year, that we received and satisfied that we received everything the state's best.
are you happy with the discovery, sir?
Do you think we received all?
Yes. But
You have any questions while we're here?
I have no question.
Huh?
I have no question.
Okay, dokie. And of course, you can talk to your lawyer later, but just want to record that you have no questions, you're happy with everything here. Or semi-happy, as happy you can get in this situation. Better if they hadn't got, if they got on the indictment, I would submit. You had a good lawyer, and I'm sure the state did a good job in getting, negotiating whatever they thought. Is there anything else?
Not from the bench, Judge.
State requested as well.
Okay. Then I have found you guilty. I've sentenced you to 12 years with $2,500 fine and court cost. Anything else? Then thank you, sir. We stand in recess, and I guess the bailiff will take you into custody.
Yeah.
And would you before I get out of town, you want to look at this and make sure I signed everything?
Sure.
It has happened. I've gotten out and we have to. Anything else, ma'am? Thank you so very much. That's what I'm here for. And could you give me a copy of that information as well? So I'll have it when I buy it. All right. Hope things go well for you. I'm not sure what the Fed's are going to do, but you seem to anticipate something.
We'll see. Thanks, and thanks for the time. Appreciate it.
That's the best fingerprint anywhere ever been.
Wow.
I think it goes too far in this week.
Appreciate it. Keep credits, meeting to be right. Okay, I'll call you up next couple hours. Okay. All right. Appreciate it.
Extended recess for this matter.
It's always a pleasure. Honor, Judge.
Always nice seeing you, sir. You have a nice day.
Good thing.
All right.
Extended recess. You can eat that. I'm gone.
Next time.
Come next time. Yay. Anything else? I guess
No, I think you're good, Judge. Thank you.
there's my copy. Thank you so very much.
Darnell Lowe's here. Waiting on him.
They work over there.
Thank you.
Do you have a copy for me, too? Mine, thanks. Okay.
You're very welcome.
Yeah, up and down.